thanks to you all for coming along this morning. I always love to come to Monash, and especially for the Social Justice Day. And I hope that I can make a contribution to this day, which unfolds with a number of young law students talking about an issue that concerns them and which they recognise as one upon which lawyers and law students can play a part. I acknowledge the presence here of Professor David Kopoloff, Deputy Vice-Chancellor, and also the former Dean, Brian Horrigan, and of Paula Gerber, my dear friend in the struggle for LGBTIQ equality, and all the new professors and lecturers that I've already learned this morning over a little party. We had a party to begin with, which is a very nice thing to have at a law school. It's not usual, but it was very welcome. And I tucked into a soy mocha, and here I am, all perked up, ready to go. Yesterday, I went to a little function for lunch with a judge who had sat with me many years ago. He was an extremely able lawyer, and he is in his 100th year. It's not Sir Anthony Mason, though I'm having lunch with him in a couple of weeks, and he will be 100 in April next year. But this other judge will pip him at the post and is becoming 100 still earlier. And he said to me, "Was it all worthwhile? Was it all worthwhile?" I doubt that it was all worthwhile. And I said, "But you've contributed to a stable and ordered society. Was it all worthwhile? But you have contributed at a very high level to upholding justice and upholding the principles of law and the rule of law. Yes, but was it all worthwhile?" And it's important that I should tell you this, because if you are law students, this is a question that is being asked by somebody who rose very high in our profession and reached pinnacles in our profession, but he was comparing his life to the life of a doctor. And he said, at least with a doctor, they know the people whose lives they've saved, they know the people whose lives they've improved, whose lives they have extended, who have shown kindness to people at the bedside and kindness in very dramatic moments in the course of the life of all of us. They have a clear worthwhileness that they can point to. Similarly with a veterinarian, and similarly with what I wanted to be when I started out, an economist. They can help organise the economy and thereby contribute to the jobs for everybody and the mechanisms of economic life that are so important to housing and to educational opportunities. Was it all worthwhile? So I've reflected last night on cases where I sat with this judge. And one of them was a case which is a reported decision very soon after we began sitting together in an appeal court. And it was a case concerning injury in a motor vehicle accident to a young man. And the injury to the young man had led to very serious cosmetic damage, as we call it in the law. That is to say, damage to his appearance and to his face. It had led him to have a number of very noticeable scars on his face, such that his friends called him Scarface. And it caused him sadness, and he had been a very good-looking young man of 18 when the accident happened. And as a result of the becoming Scarface, he said this affected his self-confidence, and he was awarded $20,000 for his injuries by the judge of the district court. And he came up on appeal, and I was sitting with my friend of yesterday, and he, I, and one other judge were sitting together. There was no issue on liability. It was a matter where the only issue was this award so low that it required the intervention of the appeal court. This has nothing to do with constitutional law. This has nothing to do with international law. This is just a little case, one of thousands that I've sat in the course of my life. And the judge who awarded the damages, general damages, to this victim of a car accident said, I may be wrong, but I think that in the case of a young man, injury of a cosmetic kind is not as serious as in the case of as a young woman. In the case of a young woman, it may result in her not being able to get married, and that would profoundly affect her life. In the case of a young man, normally it will be shrugged off and he'll get over it. And therefore, I think that he should receive a lesser sum than I would have given if he had been a young woman. And that was the case that came before us in the appeal court. And I said, when I had to give my decision, because with the pressure of work, you had to give your decision straight away, and you had to give reasons for your decision. I said, well, the judge signalled that he might be wrong. It showed that he had doubts about the principle that he was applying, and he was wrong because he was applying a stereotypical attitude to the importance of beauty, to men and women, to the young and the old, to people of the Anglo-Saxon community or people of different cultures. And it was not a correct principle to differentiate between the damage done to a young man as against the damage to a young woman. They were each individuals coming before the courts and entitled to have the court decide the case according to law, in accordance with justice and principle. The other judge of the Court of Appeal agreed with me and said, this is a case where, although there's a wide discretion given to the judge of trial in determining what should be the recovery for general damages, as it's called, it's something that should not be discriminating in terms of gender. And it might be just as important to one woman as to one man, or not so important to one woman or one man, but their gender had nothing to do with the case. And in giving gender a weight in his decision, the judge had erred in principle, and therefore the Court of Appeal was entitled to disturb the decision and make consequential orders for new hearing and a redetermination of the damages. So now it became the responsibility of my friend of yesterday to express his opinion. And he said, it's notorious that it's very difficult to decide what general damages would be, but particularly difficult in cases concerning cosmetic injury, because the impact of the cosmetic injury cannot so easily be weighed as the injury that leads to an interference in either the mental or physical capacity to earn money, and that inevitably has an impact on the amount of the damages. And in this case, we as an appeal court have to respect the primacy of decision-making of the primary judge, and I cannot say that his decision was wrong. As he said, and he acknowledged it, he might be wrong in his approach, but he is entitled to take his approach and reach his decision, and he's done that, and he has reached the decision which is now under appeal before us. And so by a majority, the view that I had expressed, that the judge had taken a stereotypical approach, was disallowed. And the verdict, the judgment that he had entered was set aside. The matter was sent back to another judge to consider it freed from the principle that the primary judge had applied, although expressing doubt as to whether he might be right or wrong. Well, he was wrong. And as I thought about today, and as I thought about his question, has it all been worthwhile? It provides me with, in a sense, a text for the purpose of my coming to Monash today and talking to you. Justice is very important. Justice is the noble cause that people who enter the law engage with. Justice is the element in the role of our legal system and of the judiciary in particular, but all participants in the legal system, that gives a nobility to the purpose of the legal profession. And if my friend, reflecting on his life, asks, has it all been worthwhile? I think that might be a reflection on a life served in the law according to mechanical approaches, according to approaches that have not been finely tuned and sensitive to the justice of particular cases. And the justice of particular cases is the issue that I agreed to come here to Monash on Social Justice Day for the purpose of talking about justice as it is practiced in the courts of Australia, and whether international law has anything to do with the discovery of justice. And lurking in the back of my mind was the possibility that I thought of, that maybe if this judge had been more attuned to the search for justice, which is a very ephemeral and changeable notion, but a notion nonetheless that lawyers are required to take into account in their work, and particularly if they become judges. This is something that might have made his life seem more worthwhile. And so at the beginning of this lecture, I want to enjoin everybody who is here to apply their minds in the purpose of the law and in their pursuit of a legal career, not just to mechanical rules, but to the principle of justice, because that is what gives our profession worthwhileness. It gives the law a really important moral character, and one in which lawyers, law students to judges, including retired judges who are reflecting on their lives, it gives them a motive force and a banner under which they have to perform their work. Now, I come from a very particular and little, even a tiny case, to a general question, which is, can we, in deciding what is just, take into account the universal principles of human rights, or that not being part of the written law of Australia as a legal principle, as a legal norm, do we just have to ignore that and apply other legal norms and reach our conclusions in a different way? Back in 1988, I went to a very interesting conference in India. A very good thing to do in your life as a lawyer is to go to international conferences, because you get new ideas and it stimulates you, and it stimulates your consideration of what is justice and how can it be found in our courts of law and in our legal system. The conference in Bangalore, now called Bengaluru, Bangalore Conference, ultimately formulated a set of principles called the Bangalore Principles on the domestic application of international human rights law. And the Bangalore Principles were formulated by a group of very senior judges, most of whom came from final appeal courts. I was one of only two who didn't come from a final court. At that stage, I was the president of the Court of Appeal of New South Wales, and that was one below the final court in Australia being the High Court of Australia. And there was another judge present at the conference with all these judges of final courts from whom there was no appeal, and this other judge was by name Ruth Bader Ginsburg. She was a judge of the District of Columbia Court of Appeals. So she was my equivalent in the United States, one below Olympus. We were both there as judges of what are called intermediate courts. And so we two were there, and the proposition that was propounded to us by a very great Indian judge, Justice P.M. Bhagwati, who was a former Chief Justice of India, the biggest common law country in the world and the biggest democracy in the world, with the responsibilities of governing 1 billion people. He propounded the principle that though it is true international principles of human rights are not as such part of the law of our own country, nonetheless, those principles can be referred to and utilised if there is an ambiguity in our law, if the law is uncertain, if there is a gap in the statute law, or if a provision in the Constitution can be given two interpretations because of the text of the document. And so that was the proposition, and the 10 judges who are present from so many countries talked about it endlessly. Ruth Ginsburg and I were sitting there and we talked about it, and we agreed with the proposition, and they became the Bangalore Principles, which were then recommended to the international community of judges and lawyers throughout the world. And when we both went back to our duties in my case in Sydney and in her case in Washington, DC, we both found that in the course of our daily work we had opportunities to invoke the Bangalore Principles. So it was that over time we propounded the Bangalore Principles to our colleagues. We wrote articles about it. We gave illustrations and examples of how, if there is an ambiguity, if there's an uncertainty, then you've got to fill the gap. And you can fill the gap by reference to these deep principles that refer to the fundamental rights of all human beings. And that is a new development, but it's a development that is suitable for the international universal age in which we are living. At about this time, the High Court of Australia, which didn't have anybody at the Bangalore meeting, handed down a decision which all of you will know of, and that is Mabo versus Queensland number 2, which is 1992, 175 Commonwealth Law Reports, page 1. And in that case, the question was, is the principle of the common law, which we have applied up to date, that denies the existence of any entitlement of the First Nations people in Australia. We didn't call them that then, the Aboriginal people in Australia. Is there any basis upon which we can question this rule, which had been handed down by judges in the colonial period and which has been treated as beyond question? And at page 42 in the Mabo decision, please have a look at it. It's 175 Commonwealth Law Reports, page 1 at 42. Justice Brennan said that although international principles are not as such part of the law of Australia, nonetheless, if there is one principle that is universal to civilized nations, it is that you cannot deprive people of a legal entitlement by reference to their race. And that was a principle which Justice Brennan applied in Mabo. He needed a key to unlock the door that would permit him, as a judge of the High Court of Australia, in the face of 150 years of land law to substitute a new principle. And he found the principle in the principles of international human rights law, no racial discrimination in the provisions of the law. And when I read the Mabo decision up there in my court in Sydney, and it came up, I said to myself, wow, this is a very big decision, but more than that, this is a big application of the Bangalore principles, because there was an ambiguity, an uncertainty, which appeared to be a wrong turning of the law, and it can be judged by reference to things that are universal to civilised countries, including Australia. And that led to the decision in the Mabo case. It wouldn't have been hard for him or me to go into a side room and write out why Mabo should have been rejected. This is land law. You don't mess with land law. Land law has the entitlements of people, big and small, corporations and individuals. Land law has been expressed for 150 years in the courts and applied. It has been decided by judges of great standing, and it is part of the definitive law of the country, and therefore we have to leave it alone. And if it is to be fixed up, it has to be fixed up by Parliament, advised by economists and anthropologists and people of expertise, and by public consultation. It can't be fixed up by the court. You get it? You understand? This is the issue. But instead of that, Justice Brennan said, the international principle of no discrimination is not as such part of Australian law, but where there is a foundation for questioning the previous law, you can have regard to the universal principles that affect all civilised countries. And so he did. And so did 6 of the 7 justices of the High Court of Australia. And overnight, not by a decision of our Parliament, but by a decision of the High Court of Australia, the law relating to land rights of Indigenous people was changed. And so over time, I came to many cases where I applied the Bangalore principles. And my colleagues in the Court of Appeal, I'm sure they would say, oh, there goes Kirby again, Bangalore, Bangalore, Bangalore. But they generally agreed with the decision, though they might have had mental reservations about the reasoning. But and then I was elevated to the High Court of Australia. And Justice Ginsburg was similarly elevated to the Supreme Court of the United States. And we kept in close contact throughout our lives on the courts because our experience had been rather similar in the way our lives developed. But at a certain stage, a decision came before the court which really tested the Bangalore principles. It was the decision in Al-Katev against Godwin. This was a decision concerning a Palestinian who had been living in Kuwait, but he was a Palestinian citizen, not a Kuwaiti citizen. And he came to Australia on a little boat and he claimed refugee status, and that was the subject of an investigation by an official of the Department of Immigration. No. It was the subject of an application to the Refugee Review Tribunal, as it then was. No. An application for judicial review to the Federal Court of Australia. No. And it then came up to the High Court of Australia. And there we all were, the 7 justices of the court. And the majority of the court said, there is no ambiguity here whatsoever. It says that if a person comes to Australia without a visa and they want to be treated under the Migration Act as a refugee, then we have to apply the refugee provisions of the Migration Act. And that says that if the person is without a visa, he or she has to be refused entry and refused recognition as a refugee because they've come without proper papers and without entitlement to be here. And that requires that Mr. Al-Khatib be sent home. But there was a little problem. And the little problem was Mr. Al-Khatib claimed to be, and he had his documents to prove, that he was a Palestinian. And the only way he could be returned to Palestine was through Israel. And Israel would not allow transit of people who claimed to be Palestinian through their territory. And so, according to the justices of the court, he had to be detained indefinitely. He had to be kept locked up in a detention camp in South Australia, and unless he could get Israel to change its mind, which was very unlikely, he would have to be detained forever. And weighing the entitlement to a visa or release from detention forever against the requirement to get a visa, the court divided. The majority of the court, and the strongest opinion was written by my friend and colleague, Justice Michael McHugh, said, what is the problem? The problem says that anybody who arrives without a visa will be detained. He is a person who has arrived without a visa. He must be detained. The Commonwealth has to try to get him back to his country of nationality if he elects to that course, which Mr. Al-Khatib had done. His country of nationality is Palestine, but to get there he has to pass through Israel. No worry that that is not happening now, and it has no concern for the language of our Act, that it may never happen, that he may be detained forever. And this is just a question of the application of the principles of giving words in valid legislation full effect. So that was the way the majority of the High Court, 4 of the justices, decided the matter. And so Mr. Al-Khatib was told to pack his goods, go back to his detention centre and stay there until he either got a visa, which was very unlikely, or he was able to persuade Israel to let him pass through to Palestine. 2 of the justices of the High Court, Chief Justice Gleeson and Justice Gummow said the hypothesis of the Federal Act is that he can be returned to his country of nationality. That hypothesis does not work in this case, in the factual circumstances, and therefore he has to be treated as if the Act does not apply to him, and therefore he will be entitled to secure a visa because the hypothesis of return is not applicable. They applied an interpretive principle of interpreting the language of the statute. I said, I agree with that approach. So if you look at my reasons in Al-Kateb, they reach a certain point after only about 3 paragraphs. It would have been the shortest judgment that I ever wrote in my time on the High Court. 3 paragraphs agreeing with Justice Gummow. However, I then said, but there are additional reasons for reaching this view, which involve the interpretation and application of the Constitution. And that led me into applying the Bangalore principles, because it could not be that a person could be detained forever. That would be oppressive to the humanity and to the fundamental rights of any individual in Australia, and under a constitution that sets up a separate judicial branch and of the judges, and therefore Mr. Al-Kateb was entitled to be released on that footing as well. So there you had the 3 approaches. 1, just apply the strict words, don't bother about anything else. 2, apply the words, but it wasn't meant to apply. The Act wasn't meant to apply to this particular case. My approach was, well, if you can, you apply the words, and it wasn't intended to apply to this case. But if it was intended to apply to this case, it would be in breach of the fundamental principle of civilized nations of keeping a person in detention forever. And so they were the 3 points of view. And the decision in Al-Kateb was challenged in about 7 cases over the next 20 years, and it was never disturbed by the High Court during that time. Every time a case came to reconsider Al-Kateb, it was struck down, removed and rejected. But then came a new Chief Justice and a new court. And in November 2023, Chief Justice Gageler was sitting in the centre seat, and there were some new judges taking part in the case, and the new judges, with Justice Gageler, decided the case partly on the Gummow interpreting the statute approach, but partly by reference to the important principle that in the Australian Constitution, unlike many others, it is expressly stated that the power to make laws in the Federal Parliament, such as the Migration Act, are to be subject to this Constitution. You look at section 51 of the Constitution, subject to this Constitution. The Federal Parliament shall have power to make laws for the peace, order and good government of the Commonwealth in respect of immigration, aliens, and it's subject to the Constitution. And subject to the Constitution invokes the provisions of the Constitution for a separate judicial branch of government, which has the separate responsibilities for protecting the liberties of all persons, and that principle of constitutional law also supported the claim to override Al-Khatib. And so in the case of NZYQ, decided in 2023, the High Court of Australia reversed unanimously the approach in Al-Khatib, and by reference to, in part, Justice Gummo's approach, and in part, the approach of a constitutional analysis, they decided that Mr. Al-Khatib was entitled, or Mr. Al-Khatib under the current law, Mr. NZYQ, was entitled to be released from indefinite detention, that under Australian constitutional law, you cannot have indefinite, unreviewable detention. And that is the matter that I came to present to you. And it's a question as to why did I bother? Why was I concerned to seek to find a solution that would be conformable to the laws of civilized nations? Well, the reason was the same as the reasons that led the High Court of Australia to its decision in a non-constitutional case, Mabo. That was just a common law case. But the principle of the law, in my view, was basically the same. And the principle of the law was the principle I learned at Bangalore. And the principle of the Bangalore rules is one that is still continuing to evolve. And if I ask, what was the point of it all? Was it worthwhile? The answer that I would give and commend to you is, lawyers march to a different drum. Lawyers march to the drum of universal human rights. It is not, as Chief Justice Brennan said in Mabo, it is not as such part of our law. But if you get to a point where there's a gap in the law, or if you get to the point where there is an ambiguity in the law, or if you get to a point where there is a very serious breach of the rules of civilized nations, that is where you can utilize the Bangalore principles and find a solution that strikes you as a just solution in the particular case. And that is what is noble, and that is what is worthwhile, and that is what makes a life in the law worthwhile. We're not mechanics. We're not flying a jumbo jet and have put it into George. George isn't flying, we are flying it. And we are flying it because that is our system of law. And it's a very important feature that distinguishes our legal system and its tradition from that of most other countries. So we'll have a big round of applause and then we can have a few questions. Ladies and gentlemen, I'm a Democrat, and not politically Democrat, but I believe there must always be an opportunity to ask a question, even if only one question. And the fact that I've gone on for too long is not a reason to take away that democratic right. So is there one question that concerns somebody in the audience? Yes. Speak up, please.
Thank you. I suppose reading through your judgments, I have always wondered, how is it that you're not affected by, I think it's very easy to be affected by the tyranny of the majority, and how is your process in seeing things so clearly and being able to approach them with your own point of view without the influence of others?
Well, everyone in my later time in the High Court said he's the great dissenter. That's not a necessary insult, because some very great judges over the centuries, Oliver Wendell Holmes in the Supreme Court of the United States, they were called the great dissenters of their time. But I never looked on myself as a great dissenter, because in the Law Reform Commission, where I was for 10 years, I didn't dissent at all. In the Court of Appeal, I dissented about 11–12%, which is a normal, slightly high rate. So I didn't consider myself as being merely curmudgeonly or a difficult person. And then when I went into the United Nations, I was usually chairing something and didn't have to dissent, and everybody agreed. So when I came to the High Court of Australia and I found that I was differing with a large number of cases, it didn't worry me. It didn't affect my psyche. I used to go home and I was greatly blessed by having a partner. Every lawyer, most lawyers need a partner. And you can say, you'll never believe what happened today. You know the feeling? And so my partner would always go through it, and then we'd have our dinner and forget about it. And I've always been a good sleeper. You just go to sleep, you forget it, you get to the next day. That's what's called professionalism. You don't allow it to disturb your psyche or your sleep. And so long as you've made your very best effort to express what you understand to be the law and explain why you differ, then that's our system. And you also know that sometimes there will be a reversal of the law, just as in NZYQ. And therefore, I never allowed that to disturb me. My colleagues were all totally honest. They were also very clever. They were all very hard-working. And they had my professional respect. And I knew that to some extent maybe there were elements in my life, my sexuality, for example, but also the fact that for all of my time on the High Court, I was the only justice, nearly all the time, the only justice who had been educated in public schools. I think values in, values out. I think that did affect a different approach. And if that was so, well, that was just it. And I just had to do my thing and they had to do their thing and the majority would rule. But in the long term, different views. That one of the great strengths of the English system of law is the right to dissent. It doesn't exist in the civilian system, in Napoleon's system, in the European system, in the Japanese, Korean, Chinese, no right to dissent. But the English always had this funny right to dissent and to express what the people who were judges truly believed. And I think that's a very particular and special, peculiar aspect of our legal system, but we can be proud of it, I think. And the fact that others had the majority, well, that's just how the system works, but it is an open system and you can disagree with the majority or you can disagree with the dissenter, but you will at least have got the different points of view of each. And that leads to an openness of our system. And that's a very important feature, and I charge all of you to preserve that. Integrity, uncorruptibility, and openness, really important features of our legal system. So thank you for that question. You have one quick question?
Sorry, might not be very quick, but basically the Australian Disabled Enterprises pays like disabled people $6 an hour as part of their model. If you were a human rights lawyer today, how would you go about challenging this? Because this is not just a Fair Work Commission issue, is it? It's clearly something related to that human rights, like the IHR that you've been discussing. And I mean, Australia is a state party to the optional protocol for the Convention on Rights for Disabled Peoples. So if you were, a human rights lawyer at the moment, how would you go about making a submission, or to whom will you make the submission to?
Well, I don't know that case, and it sounds very much to my antennae to be the type of case that might come before a court. And there is a rule binding on me as an individual not to comment on matters that might come before the court. So I can't give a bit of free legal advice on how you should go about that. But it does sound as though it has legal human rights points, and if it does, then you should not be backwards in saying, and by the way, in the case of any ambiguity, it would be appropriate to take respectfully, to take into account what international human rights says on the Convention on the Rights of Disabled Persons. And so this is the way you build up principles over time. It all depends on awareness and knowledge of law students that they can carry into their practice, and on courage. Courage is very important in the law. You've got to be courageous, and even against opposition or discouragement or non-agreement, you've got to put forward the instructions, the submissions that you believe will help your client and will help the tribunal to understand where you're coming from and why. Okay, well, that's it. We've now got the best part of the day, which is the report of the students of Monash on particular human rights challenges and the suggestions that they make. In the past, there have been such good suggestions, one of which was a suggestion that when the universities were putting up fees, they should have an exception for anybody who is in Australia on a bridging visa, and the vice-chancellors should be contacted to get them to consider such a rule, a recommendation to universities. And that was put forward at Monash by this program, and I immediately wrote to the Universities Australia, well, I think it was then the Australian Vice-Chancellors Committee, and said, this came up at Monash and I think it's a very good idea and you should give consideration to it. And they did, and they introduced a recommendation that universities should have this for people who have lost their nationality and are in a disadvantaged position. And so out of the efforts of individuals with a little bit of support and backing can sometimes come just outcomes. And then at the end of your life, you will say, well, was it all worthwhile? Was it all worthwhile? Was all that effort, all those long nights, slaving over the cases, was it worthwhile? Well, I'm here to tell you it is worthwhile if you give that extra dimension and you are concerned about the human rights of your fellow citizens and fellow human beings. That's it.